All right, who do we have ready at the jail court?
Judge, on Mr. Holloway, we're ready, but we're not going to be able to accomplish much other than a reset, as short as we can get.
What happened? I thought we were set for plea today.
I thought we were too. Apparently, there's an issue on some time credit, whether it's right or wrong. Apparently, there was a PR bond that I was not aware of. At any rate, I think we'll get it worked out still.
All right. I don't want him languishing in the jail and sitting around waiting on us. About March 28th.
That's is that a Thursday or
It's a Tuesday.
can we do it Thursday?
Thursday is contested hearing day, so I'd rather not do it on Thursday if you can avoid that.
We'll do March 28th.
All right. Court sets Mr. Holloway for re-plea on March 28th at 1:30.
And I've got a reset here, Judge, but he's in jail, so
Is he there in the courtroom? There in the courtroom with you?
yes, he is.
I just want to make sure I didn't look up to see if he was there with you. All right, Mr. Holloway, we'll see you back on March 28th.
Sir.
All right, who else is ready? Mr. Bogan, are you ready? Go
Yes, Your Honor.
ahead and bring your client. All right, this is cause number CR 2215 and CR 2264, State versus Michael Elias de la Rosa. Show that we were set on pre-trial condition issues. Not sure if we're set for anything else. Go ahead, Mr. Bogan.
Yes, that is correct, Your Honor. This case is already set on the trial docket. My client, when he reported to court, I believe, was it January 30th or 30th? 30th. On January 30th, he was taken into custody. Apparently, there was a positive drug test on January 9th. I actually didn't get notice of the positive drug test until after my client was arrested. I'm approaching the court to ask that his bond be reinstated or lowered. His bond is currently at $100,000 on both charges. Mr. De La Rosa has been coming to court for well over a year. He came to court twice in January. He has not missed a single court date. I request that, given his good attendance and given that he's been successful on pretrial conditions for so long, that the court reinstate his personal bond and admonish him about the consequences of future positive drug tests.
What would I do with the admonishment the first time of not violating conditions of pretrial release? Did that admonishment not stick with Mr. De La Rosa?
Your Honor, he has not been admonished before. This is his first failed drug test. It was on January 9th. Since then, after January 9th, he came to court on January 30th. That's when I learned of this, and he was taken into custody. And I think he's spent the last roughly month and a little about 2 weeks in jail. I think that it has made an impression on him. And I think that, given his good appearance in court, given that he's had for a year, he's been on bond with no issues, that the court could expect that if his bond were lowered or reinstated, that he would continue to show up.
All right, court's going to deny the defendant's request. I can set you for a formal hearing if you want to contest the drug test, call witnesses, make another argument. I don't know if the state's on notice today of your motion to set or reinstate bail. I can set you on March 20. I can set you on March 28th, and we can come back and have a hearing about that, or we could do it on March 30th.
March 28th, Your Honor. I can be here on March 28th.
All right, then the court will set Mr. De La Rosa for hearing on motion for bail reduction. And I'm assuming, have you filed that, Mr. Bogan?
No, Your Honor, I have not filed a motion. I can file a motion at this time. I was actually just looking for a hearing on the ruling to hold his bond insufficient, given that I actually still haven't been provided by the state with any evidence, and I haven't actually seen a motion by the state.
Well, I don't believe the state made a motion. I believe that the court did it on its own motion as the keeper of the conditions of pretrial release. I was notified, I was notified by the pretrial release officer that he tested positive on January 9th for methamphetamines. And his last payment, he's delinquent. His last payment was on April 20th of 2022. And he was delinquent for $90 in supervision fees and $25 for drug testing. So I'll make sure you get a copy of that and we'll let you take it up on the 25th.
Okay,
28.
I'm sorry, 28th.
Okay. All right. Thank you.
You're welcome. Mr. White, are you ready on Ms. Caldwell?
Yes, sir, I am.
All right, you'll go ahead and bring Ms. Caldwell up. And it's my understanding that this is going to be, the state has filed a motion to withdraw the state's motion to revoke, to continue her on community supervision. Well, let's see, it says community supervision order modified without a hearing. That's what the state's motion says. What are y'all intending to do?
Your Honor, what we're gonna do is extend Ms. Caldwell a year, and then the state and I have agreed, and I've gone over it with Ms. Caldwell. She's gonna submit to safety.
So
That's our amendment, Your Honor.
all right, so it's to be a withdrawal, continue, and amend.
Amend with, yes, Your Honor.
All right, Ms. Caldwell, if you'll raise your right hand, I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. You're going to speak up because if I can't hear you, my court reporter can't hear you.
Yes, sir.
All right, you can lower your hand. All right, Ms. Caldwell. Mr. White has announced to the court that you've reached an agreement on how to resolve your motion to revoke that's been filed by the state. It's indicated to me that the agreement is the state's going to withdraw its motion and your community supervision conditions are going to be amended to include a new condition that you attend the substance abuse felony punishment facility, also known as SAFE-P, a drug rehab. Is that correct?
Yes, sir.
All right. Is that what you're wanting to do today?
Yes, sir.
Has anybody forced, threatened, pressured you, done anything to make you make this agreement today, or are you doing this of your own free will in the court? You're going to have to speak up or I can't hear you. Your free will, you're doing this because this is what you want to do.
Yes, sir. I have no other choice.
Okay. All right, then the court will find that Ms. Caldwell has intentionally, knowingly, willingly agreed to the modification of her community supervision conditions to include SAFE-P. Court will approve the agreement between the state and the defendant. Court will grant the state's motion to withdraw, the state's motion to revoke, and continue community supervision with SAFE-P as a condition of Ms. Caldwell's community supervision. Anything further, Mr. White?
No, sir.
All right, then if there's nothing further, we'll be adjourned in this case. All right, I think the rest are Mr. Manning's.
Judge, just for the court's information, there was a hiccup with probation with one or two of the morning pleas. Mr. Manning's at the probation department. He may be a little late. He had us wanted us to inform the court that was what was going on.
Okay, All right, we'll stand in recess until Mr. Manning appears.
Thank you, Your Honor.
He's here. Judge, Mr. Manning's here.
Okay, thank you, sir. I'll give him time to talk with his clients.
Yes, sir.
Judge Martin, are you still at the bench?
All right, do we have counsel that's ready? All right, Mr. Manning, who are you ready on?
Judge, let's get started. We have some pleas we can go through.
Who are you ready on?
Bobby Lee Morris Jr.
All right, this is cause number CR 2021. And also, yeah, let's see, that's all of this waiver. Everything. Okay, Mr. Morris, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right, you can lower your hand. All right, Mr. Morris, your name is Bobby Lee Morris Jr., is that correct?
Yes, sir.
And Mr. Morris, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with his representation of you?
Yes.
Do you feel like you've had enough time to talk with him about your case and have all of your questions answered?
Yes.
You've read over some paperwork today and you've signed. Are you comfortable that everything you read and signed you understand right now?
Yes.
Do you have any questions about anything?
No, sir.
Mr. Manning, do you believe Mr. Morris to be competent today?
Judge,
And have you explained to him his rights as they pertain to the plea?
I have, Judge, not only his rights as it pertains to trial and a plea, but also we've waived indictment at this point and proceeding by information. I've discussed his rights as it pertains to discovery as well as time to prepare, and he's willing to waive all his rights to go forward today.
All right, and I see that Mr. Morris has waived his right to an indictment and is proceeding by information. Is that correct?
That is correct, Judge, and we have a waiver of indictment.
Okay. All right, Mr. Morris, you are charged by information with the state jail felony charge of theft of property less than $2,500 with 2 or more previous convictions. A state jail felony in the state of Texas carries a range of punishment if convicted and sentenced to not less than 6 months in the state jail prison and not more than 2 years in the state jail prison, and a fine if imposed of not more than $10,000. Do you understand that full range of punishment?
Yes, sir.
I see the plea agreement in your case is that you want to waive your right to an indictment, allow the state to prosecute you on the information. You want to accept a plea agreement wherein you would plead guilty to that crime, and the state would recommend that the court convict you today and assess your punishment at 14 months in the state jail division of TDC. In addition, the court would assess a $2,000 fine plus court costs and reimbursement fees, and you would receive 31 days credit towards your sentence for time that you've been in jail on this case. Is that correct?
Yes, sir.
Okay. And Mr. Morris, you understand that you have the right to have your case presented to a grand jury, and that grand jury would hear the evidence and determine whether or not there's sufficient probable cause to move forward with a prosecution in your case. You understand that, right?
Yes, sir.
You understand that, yeah, only you can waive that right. Mr. Manning can't waive it. The court can't waive it. No one else can waive it but you. You understand that as well?
Yes, sir.
And today you're telling me that you've been accused of a felony. You understand your right to a felony indictment, and you are waiving that right today and allowing the state to prosecute you by filing an information. Is that correct?
That's correct.
All right, the court will find that Mr. Morris has waived his right to an indictment, has been admonished regarding his rights. Court finds that he's intentionally, knowingly, and voluntarily waiving his right to indictment, and it is joined by his attorney, Mr. Jonathan Manning. All right, so Mr. Morris, I would ask you at this time, how do you plead to theft of property less than $2,500 with 2 or more previous convictions?
Guilty.
And Mr. Morris, are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty today?
No.
All right, court accepts Mr. Morris's plea of guilt. Mr. Manning, any objection to the state's evidence?
Object to state's one, Judge.
States 1 is admitted, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, state would rest and close.
Anything further from the defense?
Judge, I would just point out that the state is also rejecting two other cases. And while that is not in the judgment, they've included paperwork that says decline for prosecution under prosecution of this case.
And that will be noted for the record. All right, then the court's going to review the evidence briefly. All right, the court has reviewed the evidence, finds that there is sufficient evidence to convict Mr. Morris of this offense. The court will follow the plea agreement reached in this case. Court hereby convicts Bobby Lee Morris Jr. of theft of property less than $2,500 with 2 or more previous convictions. Court assesses his punishment upon conviction at 14 months confinement in the Texas Department of Criminal Justice State Jail Division. Orders him to pay a $2,000 fine, $290 court cost, $15 reimbursement fees, and the court issues him jail time credit of 31 days for the time that he has spent in jail on this cause. Mr. Morris, you hereby remanded to the custody of the Van-Dyke County Sheriff so that he can carry out the terms and conditions of the sentence. I'll have you step over with the deputy to be fingerprinted. Good luck to you, sir.
Judge, and just one more thing. Mr. Morris requested the court's explanation about good time credit. I explained to him that the good time credit is something that's discretionary for you, that you review those reports electronically, that if they participate in the programs and have good behavior down there, that you review those and grant them as they come to you. But he was just wanting to make sure that was part of the record.
Yes, Mr. Morris. So the court monthly reviews all what is called diligent participation credits. And those are delivered to me electronically by the Texas Department of Criminal Justice. And within that report, I receive information regarding any educational classes that you are enrolled in, whether you complete those. I also receive information if there's any disciplinary conduct. And then they indicate to me how much time I can award. And the court reviews each one of those subjectively. That means I look at case by case basis. I also look at the underlying cause and the length of sentence, and I calculate all those things, and then I make a decision on whether or not good time credit will be issued. And so I'll do the same thing for you whenever you reach that period in which you're eligible. Okay.
Yes, sir.
All right. Ready on next, Mr. Man.
Ready on Mr. Braylon Hicks.
All right, this is CR 22-356, CR 22-399, State versus Braylon Diamante Hicks for pretrial. Go ahead, Mr. May.
Judge, this week I received an offer for Mr. Hicks's case from the DA's office. I would like to reset it so I have an opportunity to sit down because of the charge that it is. I'd like to sit down and take some time to go over that, and I was unable to do that this week. So I request a short reset for me to be able to go over that, discuss that with him.
Okay. Do you want to come back on March 30th? That is a Thursday. That'd be the evidentiary docket.
Yeah, Judge, that'll work.
Okay. All right. Court sets pretrial for Mr. Hicks on March 30th at 1:30. Who's next, Mr. May?
Judge, ready on Mr. Hunter Tapper.
Hunter Tapper, CR 22-342, CR 20-371.
Judge, I don't know if you have the paperwork in front of you, but we're proceeding on a motion to dismiss.
I I do have it, Mr. Manning.
Okay.
I appreciate it though. All right, Mr. Tapper, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, and also show that we're on. I think I said it, CR 22-342 as well. All right, Mr. Tapper, you appeared before the court. On October 14th of 2021, on the charge of possession of a controlled substance in penalty group 2, a state jail felony. The court heard the evidence, found that there was enough evidence to convict you. However, the court followed a plea agreement that you reached with the state that day. And the court approved the plea agreement, placed you on deferred community supervision for a period of 3 years. The court also assessed a $1,500 fine. It was during that period of time that the state filed its motion to adjudicate and revoke your community supervision. That was filed on May 12th, 2022. In that motion to adjudicate, the state has alleged 4 individual counts of ways that they believe you have violated. Mr. Tapper, have you had enough time to talk with your attorney, Mr. Manning, about your motion to adjudicate?
Yes, sir.
And have you had all your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read over and signed today that you do not understand? All right, Mr. Manning, have you explained the state's motion to Mr. Tapper and his rights responsive to that motion?
I have, Judge.
And do you believe that he is entering into this agreement intentionally, knowingly, and voluntarily?
I do.
Does your client waive the formal reading of the state's motion to adjudicate?
He does?
Is it his intent to plead true to all 4 counts?
Yes, Judge.
All right, Mr. Tapper, then, as to the state's motion to adjudicate, as to counts 1, 2, 3, and 4, are those counts true or not true?
True, Your Honor.
And are you telling me that those counts are true because in fact, what is alleged in those counts is in fact true? You're not just saying that to get a certain plea agreement?
Yes, sir.
All right, the court will accept the defendant's plea of true. Mr. Manning, any objection to the defendant's waiver of rights being admitted, the defendant's admission and waiver of rights being admitted into evidence today?
No objection.
All right, then court admits the defendant's waiver of rights and plea of true to state's motion to adjudicate. Court also takes judicial notice of Mr. Tapper's judicial confession. Anything further from the state?
Your Honor, not with respect to the motion to adjudicate, however, in CR 22-00342, Mr. Manning does have in his possession a motion to dismiss based on the request of the complainant. I met with the victim of that cause number here in our office. She signed an affidavit of non-prosecution and indicated to me that she did want to forego moving forward with any more charges against Mr. Tapper. So we have submitted a motion to dismiss on that cause.
Thank you, Ms. Heisel. Anything further from the defense, Mr. Manning?
Nothing from defense.
All right, then based on the evidence in CR 2371, court finds that Mr. Hunter Tapper has violated the terms and conditions of his community supervision. The court will follow the plea agreement reached between the defense and the state. Court hereby revokes Mr. Tapper's community supervision, convicts him of the offense of possession of a controlled substance in penalty group 2 less than 1 gram. Court revokes his community supervision, assesses his punishment at 12 months confinement in the state jail division of TDC, orders him to pay the balance of his financial obligations, and the court awards Mr. Tapper 10 days credit for the time that he has spent in jail on this cause. With regard to CR 22-342, the court grants the state's motion to dismiss. Mr. Tapper, you hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I have you step over to the deputy to be fingerprinted. Who's next, Mr. Manning?
Judge, if we can call Mr. Michael Murphy.
Michael David Murphy, CR 22-153, set for pretrial.
Yes, Judge, I've reviewed the discovery in this case, and I'm gonna be filing a motion to suppress. I discussed that motion to suppress when I spoke with the state on Monday. And I unfortunately, because of everything that's happened this week, I was unable to get it filed before today, but I will be requesting the March 30th date, and we'll have that timely filed before the setting on the motion to suppress.
Any objections from the state?
No, Your Honor.
It was a race to see who could unmute faster. No, Your Honor.
And Mr. Manning, that motion will not be a boilerplate motion, correct?
Well, Judge, we're gonna allege that the statements and the evidence and the stop all be found illegal. So I guess if you mean by boilerplate everything, then no, it will cover everything. But I provided the specifics of my motion to the state, and they've said we need to go ahead and set it for a hearing.
Right, no, I'm not talking about what you want suppressed. I'm talking about the reason. It's not gonna be boilerplate as to the reason for the suppression. Stop is too long, racial profiling, no probable cause for a specific reason.
Well, Judge, there's a lot of reasons why the evidence shouldn't be suppressed. But if you like, I can include all that in my motion for the state. Like I said, I've already discussed it some with the state as well.
Yeah, I want a narrowly tailored motion so that we can hone in on the issues that are going to be before the court on the 30th, since it's not been filed today. If it had been filed, I could review it right now and tell you whether or not I would set it for the 30th. But as an officer of the court, you're telling me that you're going to file it. So I will set it for March 30th. But what I am asking for is for it to be narrowly tailored to include the reasons for the suppression.
Yes, Judge, I'll narrowly tailor it to each of the officer's violations.
Alleged violations.
Right.
It's not often I get to say alleged.
Alleged violations.
All right, we'll see you back on March 30th, Mr. Murphy. Who do you like next?
Judge, ready on Mr. Joshua Mills.
Joshua Daniel Mills, CR 22-382, CR 22-383. Mr. Mills, if you'll raise your right hand, sir, I'm going to place you under oath. Mr. Mills, do you swear that the testimony you give to the court today will be truth, the whole truth, and nothing but the truth, so help you God?
I swear.
All right, thank you, sir. You can put your hand down. Your name is Joshua Daniel Mills, is that correct?
Yes.
Mr. Mills, are you a United States citizen who reads, writes, and speaks English?
Yes.
Have you ever been diagnosed with a mental condition?
Yes.
Can you tell me about that?
When I was in the military, I was diagnosed as a narcissistic sociopath.
Okay, are you currently on medication or under treatment for that?
No.
Do you feel like not being on medication or treatment is in any way inhibiting your ability to understand this case that's being brought against you?
No.
In this case, you are represented by your attorney, Mr. Jonathan Manning. Are you pleased with his representation of you?
Yes.
You feel like you had enough time to talk with him about your case and that you've had all of your legal questions answered?
Yes.
And is there anything about this paperwork that you've read and signed today, Mr. Mills, that you do not understand?
No.
Thank you, sir. Mr. Manning, do you believe that Mr. Mills is competent today? Have you explained to him his rights? And do you believe that he's entering into this plea intentionally, knowingly, and voluntarily?
He is competent. I do believe so that he is entering in potentially knowingly and voluntarily.
All right, Mr. Mills, you are charged by indictment with a third-degree felony offense of smuggling of persons. A third-degree felony carries a range of punishment of not less than 2 years in prison or more than 10 years in prison, and a fine, if imposed, not more than $10,000. I see that there is a plea agreement in your case wherein you would plead guilty to that crime. The state would recommend that your sentence be assessed today at 4 years confinement in prison with a $2,000 fine plus court costs and reimbursement fees. you would receive 157 days credit for the time that you spent in jail already. And the state would be dismissing CR 22-385, evading arrest with a vehicle pursuant to their agreement with your plea in this case. Is that your understanding, Mr. Mills?
Yes.
And Judge, if I may, I believe that may have been an incorrect typo on the judgment. I believe it's CR 22-382. Or at least that's what the 1245 payment says. As well as his docket number.
Yeah, that appears to be the case. So I'll need a new front page for Mr. Mills to correct the 1245 language in the terms of the plea bargain to reflect CR 22-00382 rather than 385. All right.
I'll bring it over this afternoon, Judge.
Thanks, sir. All right, Mr. Mills, then I would ask you, understanding the plea agreement, understanding the range of punishment, how do you plead to smuggling of persons?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes.
And has anyone threatened, forced, or pressured you to plead guilty today?
No.
All right, court accepts the defendant's plea of guilt. Mr. Manning, any objections to the state's evidence?
No objection to states one.
States one is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, we addressed in close.
Anything further from the defendants?
Rest of close, Judge.
All right, court will review the evidence briefly. All right, the court has reviewed the evidence, finds sufficient evidence to convict the defendant of this offense. The court will follow the plea agreement. Court hereby convicts Joshua Daniel Mills of smuggling of persons, a third-degree felony, assesses his punishment at 4 years confinement in the Texas Department of Criminal Justice, orders him to pay a $2,000 fine, $290 court cost, $20 reimbursement fees. The court takes into consideration under section 1245 CR 22-00382, and the court awards Mr. Mills credit for time previously spent in jail on this case of 157 days. Mr. Mills, you hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Please step over with the deputy to be fingerprinted. Who you like next, Mr. Manning?
Judge, if I make an announcement on Mr. Ozuna, I was informed when I arrived at the jail this afternoon that he was refusing to be brought up. I am now being told that he has changed his mind and would like to appear. At this point, Judge, I don't know if I've ever gotten back the order that we had signed or was presented to be signed last court date on the motion to compel. And until I can get that, I'm unable to get DPS to produce and me examine the discovery that was requested.
Is he in the courtroom with you?
He's not currently here.
All right, well, let's wait. I'll look it up. Let's wait until he gets in here and then let's call someone else up.
Yes, Judge. I'm sorry, I was unaware that he was wanting to be here. Judge, we can call Mr. Larry Rudd.
Larry Rudd, CR 21-369 for pretrial.
And Judge, he's gonna be just a minute. He's walking a little bit slow today.
It's fine.
Judge, Mr. Rudd has been in Dallas County, and I've been unable to go over to discovery with him since our last court date face-to-face, when I was over at JP2. We request an additional reset for me to go over to discovery with him tomorrow and prepare for any pretrial issues we may have.
Any objections from the state?
State would be unopposed, Your Honor.
All right, court will reset Mr. Rudd for pretrial on May 11th.
Judge, ready on Mr. Clarence Smith.
All right, court calls. Call numbers CR 22-285, 286, 287, 288, 289, 290, 291, 292, State versus Clarence William Smith.
Judge, there was a motion for requested funds to retain a forensic expert. I was given a item of a digital nature that I would like to have examined. I filed that motion, I believe, either Friday or Monday, and request funds and I guess request a hearing on that if we need one.
The court reviewed your motion yesterday, granted your motion, signed it in e-file, and returned it to the clerk for filing yesterday.
Okay. Then other than that, I guess if we can hold off docket call, we received an offer, and I'd like to see what this phone contains before we move forward one way or the other.
All right, let's set Mr. Mr. Smith for docket call and status of forensic evidence discovery for May 11th. Who do you want next?
Judge, if we can call Haley Saunders.
Haley Delaney Saunders. Ms. Saunders, if you'll raise your right hand, I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Your Honor.
All right, thank you. Don't lower your hand. All right, Ms. Saunders, are you a United States citizen who reads, writes, and speaks English?
Your Honor.
Have you ever been diagnosed with a mental condition?
Yes, Your Honor.
Can you tell me about that?
Just PTSD and anxiety, Your Honor.
Are you currently on medication or undergoing doctor's care for those?
Yes, Your Honor.
All right, do you feel like you have a rational understanding of what's going on in this case today?
Yes, Your Honor.
And today, Ms. Saunders, you are represented by Mr. Manning, your attorney. Are you pleased with him and his representation?
Yes, Your Honor.
Do you feel like you've had enough time to talk to him about your case and that you've had all of your legal questions answered?
Yes, Your Honor.
And is there anything about the paperwork that you've read over and signed today that you do not understand?
No, Your Honor.
All right. Mr. Manning, do you believe that Ms. Saunders is competent today?
She is, Judge.
And you've explained to her what it means to waive her rights of indictment. And you've explained to her her rights regarding the plea. And you believe that she's entering into this plea intentionally, knowingly, and voluntarily.
She is, Judge.
All right, and Ms. Saunders, you understand that you have the right to have your case presented to a grand jury, and for that grand jury to listen to the evidence and make a decision whether there's enough probable cause to go forward with a prosecution against you. You understand that?
Yes, Your Honor.
And you and only you can waive the right to that indictment. You understand that?
Yes, Your Honor.
In order to waive your right to an indictment, it has to be done so intentionally, knowingly, and voluntarily. That means it has to be something that you've decided to do of your own free will and accord. You understand that?
Yes, Your Honor.
Have you made that decision in this case to waive your right to an indictment freely of your own will?
Yes, Your Honor.
All right, has anyone threatened you, forced you, or pressured you to make you feel like you had to waive your right to an indictment?
No, Your Honor.
All right, the court will approve the waiver of indictment in this case and find that Ms. Saunders has had the advice of counsel. Court's going to find that she's entered that waiver. She's entered into that waiver intentionally, knowingly, and voluntarily. Ms. Saunders, you are charged by information with the offense of aggravated assault with a deadly weapon, a second-degree felony. If convicted, you could be sentenced anywhere from the minimum 2 years all the way up to a maximum 20 years in prison, and a fine could be imposed, but it could not exceed $10,000. Do you understand that full range of punishment?
Yes, Your Honor.
I see that the plea agreement in your case is that you would plead guilty to aggravated assault with a deadly weapon in exchange for the state's recommendation that your punishment be assessed at 10 years in prison, for that sentence to be suspended, and for you to be placed on 10 years community supervision with a $2,000 fine, $290 court cost, and $515 in reimbursement fees. In addition, the state would be asking the court to dismiss a possession of controlled substance, a deadly weapon in penal institution, another possession of controlled substance, and a failed to ID fugitive as part of this agreement. Is that your understanding of the plea agreement, Ms. Saunders?
Yes, Your Honor.
All right, Ms. Saunders, then the court will ask you this time, how do you plead to aggravated assault with a deadly weapon?
Guilty, Your Honor.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, Your Honor.
And has anyone threatened you, forced you, or pressured you to plead guilty today?
No, Your Honor.
All right, court accepts the defendant's plea of guilt. Mr. Manning, any objection to the state's evidence?
No objection to state's evidence. Judge, I would point out that there were no actual injuries in this case. It was an assault by threat, and just Ms. Saunders, when you asked earlier, Ms. Saunders was the one that reached out. She recognizes that her troubles kind of begin and end with her drug use, and so that's why she requested safe P in this situation.
Is safety a condition for community supervision?
Yes, Your Honor.
Yes, Judge.
Okay, I didn't see that in here. I mean, it may be in the plea, it may be in the conditions of community supervision, but I did not see that in the plea. So, okay, anything further from the state?
Yes, Your Honor. State is in compliance with victim notification in this cause. There's nothing to submit to the court at this time in writing. However, I can tell you that the victim is supportive of Ms. Saunders receiving inpatient drug treatment.
All right, thank you, Ms. Hazel.
And Judge, that is a part of the conditions of probation.
Okay. All right, then of course, we'll review the evidence briefly. All right, the court has reviewed the evidence that does find sufficient evidence to convict the defendant of this offense. The court will follow the plea agreement reached in this case. Court hereby convicts. Give me just one moment here. Let me review something.
And Judge, also, I just received word from Ms. Ventura here at the jail that the judgment will need to include the order of safety. And I do not see that on the judgment, so.
Okay. Give me just one moment here. Stand by. Ms. Saunders, go ahead and have a seat. I'll be with you in just a moment.
Yes, sir.
Mr. Manning, check yourself out. All right, Mr. Manning, did you explain to Ms. Saunders that we're gonna call her back up in a moment?
I did, Judge. I told her we wait to probably towards the end of this docket to get the time for them to complete paperwork.
Okay, who's next?
Judge, we can call it Mr. Davis.
All right, Mr. Davis, if you'll come forward. This is Michael Edward Davis, CR 22176. Go ahead, Mr. Manning.
Judge, Mr. Davis was recently arrested on some new charges. And so I request that we reset pretrial in order to give a chance to get everything caught up and figure out where we're at.
Any objection from the state?
No, Your Honor.
All right, court will reset pre-trial for Mr. Davis to May 11th.
I'm sorry, Judge, what was the date on that?
May 11th. Who's next?
Mr. Ehrenfeld.
Kevin Max Ehrenfeld, CR 22-270, and then 2022-365.
Judge, this is kind of an interesting situation. Mr. Ehrenfeld's been in Rains County, and I've been unable to communicate with him. My understanding through a third party was that he was ready to get back here and get his stuff taken care of. And that's partially true, just not in the way that I thought. And so I would request that we reset for me to discuss the potential resolutions of his case with him and iron out an agreement if there's one to be had.
Okay, so I was under the impression that he was going to plead today.
Yes, Judge. He received a similar sentence in Rains County. And like I said, I did not speak to him personally prior to sending him today, but my understanding through a third party was that he was on his way to the VA hospital for inpatient treatment in the veterans program, and that time was of the essence to get his case resolved. However, speaking to him, he had a couple concerns that need to be addressed, and we just like if we can set him to the 30th just a short reset for, give me some time to go over those concerns with him.
Your Honor, can I speak?
No, I want you to let Mr. Manning do the speaking for you, okay? Court's going to grant Mr. Manning's request, and we'll set this for docket call on March 30th.
I don't think, not even.
Who's next? What about Mr. Poe? Or Ms. Moore?
Let's do Mr. Poe, Judge.
Mason Gregory Poe, CR 2276, motion to revoke.
Excuse me, Judge.
We got him on my page 9.
Yes, Judge, and for some reason, my docket did not have my name next to his case, and so I apologize, but I did not bring my case file with me.
State, do you know if there's an offer that's been made to resolve Mr. Pope's case?
Judge, I'm unaware. This is Ms. Heisel's case, I believe. I don't see an offer in our online system. I don't know if one has been relayed or not. If I would believe if we can set it for the 30th, either we'll reach some resolution or be able to proceed at that time, if that's all right with Mr. Manning.
And Judge, I was just appointed on the 2nd. And I don't show that an offer has been conveyed at this point in time.
Okay, then what we'll do is we'll set him on a contested hearing docket March 30th. That'll give the state some time to extend you an offer if they choose to do so. And if not, then give you time to make your own offers, and then we can have a contested hearing if no resolutions made.
Mr. Manning, we just added you to our online portal. We still had his prior counsel as counsel of record, so it's not surprising you don't have anything yet.
Yeah, and I appreciate that. In the docket still doesn't have an attorney listed, so.
All right, Mr. Manning, I show a Randy Young, also show Haley Saunders, Kayla Moore, And then Mr. Ozuna.
Yes, Judge, I'm ready
On Young. All right, this is State versus Randy Leonard Young, CR 22-349 for pretrial. Go ahead, Mr. Manning.
Yes, Judge. So Mr. Young was taken into custody at our last court date. And I received an offer on Monday that I need to convey to Mr. Young, as well as discuss discovery in his case, and he's also asked me to file a bail reduction in his case. I request that we be reset for the March 30th date.
All right, court will set pretrial March 30th, 1:30 p.m. All right, Mr. Manning, who do we have?
This is Ms.
I'm sorry, I interrupted you. Who did you say?
Kayla Moore.
Okay, that's what I thought. Kayla Joe Moore, CR 18-442. Amended motion to revoke. Go ahead, Mr. Manning.
Judge, we are close on the offer. We received an offer on the case. I was able to convey it to my client, and she has a counter offer that she'd like for me to convey to the state. If we can set it out for that March 30th date, I think we'll be able to get this one resolved.
All right, court will set this for a contested hearing on March 30th. And the court will entertain a plea that day if there is one. All right, Mr. Manning, is Mr. Ozuna there?
Judge, he is not at this time. Do you want to go ahead and take Ms. Saunders' case back up?
Sure, if we're ready.
The new paperwork is being sent over the jail as we speak.
Okay. So everything's gonna be the same with the exception that it'll be deferred. Fine will be the same, court costs, reimbursement, all the 1245s. Information will be the same. Everything's gonna be the same except we're going from straight to deferred, correct?
Correct, Your Honor.
Okay. All right.
It looks like nobody told probation when they were fixing the paperwork, so if we could have just a moment for Ms. Matura to get that straightened out.
Sure, no problem. Is Mr. Ozuna not wanting to come to court?
Judge, the message I received when I arrived here today was that he did not wish to appear, and then as I was making the announcement, Deputy Everett informed me that he had changed his mind and did wish to appear. And so that's the last I've heard.
So are we gonna double check with the defendant to see if he wants to appear? Is that what we're doing?
I'll have the deputies do that.
No.
Yeah.
Deputy Everett, did you have an update?
They are going back to his cell to get him now.
Okay, so he's wanting to appear?
Yes, sir.
Okay, thanks, sir.
It's 20 degrees from the hallway.
Yes, sir, Mr. Manning.
Judge, Mr. Ozuna's here as well as Ms. Saunders, and I think that's the last two I've got.
All right, Mr. Ozuna, come on up, sir. This is CR 22-385, CR 22-282. All right, Mr. Manning, I understand that you filed a motion to compel and you're requesting court order to inspect the I believe DVR or digital video recording device. That
As
was,
well as physical evidence as well. Yes, Judge.
okay. Remind me, I think we took this up at the last hearing too. Is that correct?
Yes, Judge.
And remind me, State, was there any objection to that?
Your Honor, there was no objection. I don't know that the signed order was given, so the state did not know at the last hearing where exactly that was because it was collected by the Texas Rangers. We have since learned that it is in possession of the Smith County Sheriff's Office. We're under the impression that they are going to download that and provide it. However, they have not done that yet. We've let them know that this motion is outstanding. So because of that, we would have no objection if the defense would like to request an expert to get that done more quickly from their side of it. We wouldn't object to that, but we don't have it in our possession currently to produce.
And Judge, with that, I do have an expert that is in Smith County that would be able to collect that. I would just have to request those funds as Mr. Ozuna is indigent, just like Mr. Smith.
Okay. So what I would like to see is a request for the funds and a motion in order. And then I need a specific order as to what it is that's to be produced by the state. Right now, as the order is written, it just says of all the items designated above, and then there's nothing designated. So I think the order is going to need to be specific if another agency is going to be relying on it.
Yes, Judge. I will get both the order granting as well as the request for funds. I know that I think in my order or my request for Mr. Smith, I put a specific amount in. I'm unsure as the specific amount, but I know it is going to be above what a one phone dump would cost. And so I'll try to put in whatever amount I'm able to get as a quote. I'll put that in for Mr. Ozuna's case.
What do you anticipate the amount for a one phone dump is?
One phone dump, I believe the price I was quoted was $1,500. And then for a DVR, it sounded like there was more time that was required both due to hardware as well as the analysis off of that type of device.
And when you say analysis, are you talking about a report produced by the software or a report produced by the forensic examiner? Are they going to be producing a report that is date and time stamped regarding things that they find, or is it just going to be a report that the software automatically does once it completes its search?
Both, Judge.
Because you may have problems on that other case, because I think I didn't know how much. There wasn't a request to the amount on that other case where you asked for a forensic examiner. And so I limited it to 1,000 without further court approval. Because I didn't know how much these guys were charging these days. So if you know it's going to be more than that, then you're going to need to give me something on the other case as well.
And I apologize. I thought I put in there. I was going back and forth with a couple different people, and I think the one that was the cheapest and ended up going with was $1,500 for a single phone dump.
Well, there's a chance that I may have overlooked that in the motion. So if that's the case, just shoot Ms. Taberham an email regarding the quoted price, and then that way I can give you an order to allow you to do that.
Yes, Judge. And just for the record, with Mr. Ozuna here, I'll let him know that up to this point and prior to the state's announcement, I've been unable to locate the physical location of the order discovery, which we now know is in Smith County. And so I will be getting an order to the court for Smith County to turn that over to an independent expert that's hired with funds provided by the court to examine that and get us to us sooner rather than later.
All right, the court will grant that order, grant the motion, sign the order when it's presented. All right, let's set Mr. Ozuna then for additional pretrial on May 11th. All right, are we ready on Ms. Saunders?
Yes, I believe. So,
All right, we are back on the record. In cause number CR 23-40, cause number 2022-308. All right, I'm gonna backtrack a little bit, Ms. Saunders. I'm gonna go back over some information we've already talked about, just because I want to make sure that you're clear on what we're doing today, okay?
Yes, Your Honor.
You understand that you're still under oath as to your testimony, right?
Yes, Your Honor.
All right, so when we were discussing your case, I arrived at the point where I saw that the proposed plea agreement was that you were going to plead guilty to this crime. And it was the state's recommendation that the court convict you of this offense, sentence you to 10 years in prison, suspend that sentence and place you on 10 years probation. And it was at that time that the court had concerns and then subsequently determined that that sentence would not be legal under the law. And so what Mr. Manning and Ms. Heisel have indicated to me now is that your plea agreement is going to be changed to that of what is called a deferred adjudication, which means that the court would still review the evidence. And if the court finds that there's enough evidence to convict you, if the court follows the plea agreement, you would not be convicted of the offense today. The court would defer a finding of guilt, and the court would still place you on a period of community supervision. The risk for you, though, Ms. Saunders, is that in the previous plea, your sentence could, if you violated your community supervision and the court had a hearing, found that you violated, and the court revoked you and sentenced you, the court would not be able to sentence you to anything higher than 10 years. That would have been the maximum part of your sentence, the maximum top of your sentence, okay? Under this revised agreement, if you plead to deferred adjudication, if later you violate your community supervision and a hearing is held, the court could then assess your punishment higher than 10 years. It could go all the way up to 20 years. It could go all the way from the lowest end of 2 years, all the way up to the highest of 20 years. And that's the legal difference between deferred adjudication and what we call a straight probation when it comes to sentencing. One of the benefits that you would receive is that if on the deferred adjudication, if you successfully complete your community supervision, then the case is dismissed
Yes, Your Honor.
versus having a felony conviction on your record. And I don't know, are you a convicted felon at this time?
No, Your Honor.
So once I brought that to Mr. Manning and Ms. Heisel's attention, then they've indicated that your plea should be changed to deferred adjudication. Have you had enough time to talk to Mr. Manning about that so that he can explain to you the advantages and disadvantages of a deferred adjudication?
Briefly, yes, Your Honor.
Do you think more time is needed? Would it be helpful to you?
No, Your Honor.
Mr. Manning, do you concur with your client? Do you think she needs any more time to understand the advantages and disadvantages of changing her plea at this time?
no, Judge, and I explained the deferred as the same way the court did, that it provides benefit and detriment as long as she continues doing what she said she's going to do, which is get treatment and get help and do probation, then she will avoid a felony conviction. However, if she doesn't do what she said she's going to do, then she will put herself at greater exposure for that full 20 years. And we just did discuss that prior to going forward today.
Okay, so Ms. Saunders, do you feel like you understand the change in your plea at this time?
Yes, Your Honor.
And do you want to go forward with this type of plea?
Yes, Your Honor.
And are you certain? Are you certain? Are you sure that's what you want to do?
Yes, Your Honor.
Your Honor, if I may just have a moment.
Sure. Go ahead, Mr. Manning.
Judge, we're ready to proceed. Ms. Saunders' questions revolved around the safety condition and just making sure that that was still in place and nothing changed with that.
Okay. And you know now, Ms. Saunders, that nothing about your agreement today changes other than you would not be convicted today and you would be exposed to the full range of punishment, minimum 2 years, maximum of 20 years, if you violate and the state proves that to the court. And the benefit, as Mr. Manning has said, and the court has said, if you complete it, then your case is dismissed.
Yes, Your Honor.
So understanding all of that, do you still wish to go forward?
Yes, Your Honor.
Okay. All right, then, Ms. Saunders, I would ask you at this time then, how do you plead to aggravated assault with a deadly weapon?
Guilty, Your Honor.
Are you pleading guilty to that crime because you are guilty of committing that crime and for no other reason?
Yes, Your Honor.
And Ms. Saunders, has anyone threatened, forced, or pressured you to plead guilty today?
No, Your Honor.
All right, the court will accept the defendant's plea of guilt. Mr. Manning, any objection to the state's evidence?
No objection to states one.
All right, states one is admitted. The court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, we'd rest and close.
Is there any victim compliance or notification issues the court should be aware of?
Sorry, Judge. Yes, we, same announcement from previously. We contacted the victim yesterday, let him know, and he was supportive of her getting that drug treatment placement.
Thank you. Anything further from the defense, Mr. Manning?
No, Your Honor.
Okay. All right, and I believe the court briefed to the evidence before. And the court does find that there is sufficient evidence to convict Ms. Saunders of this offense. The court will follow the agreement today. The court will defer a finding of guilt, place Ms. Saunders on, is it 10 years, Mr. Manning?
Yes, Judge.
On 10 years deferred community supervision. Court will order her to pay a $2,000 fine, $290 court cost, $515 in reimbursement fees. The court will dismiss under section 1245. Cause number 2022-308, a possession of controlled substance, unfiled DA 2023-178, a deadly weapon in penal institution, DA 2022-1017, possession of controlled substance, and DA 2022-1018, failure to ID fugitive with intent to give false name or information. Court also, as a condition of community supervision, orders Ms. Saunders to attend the substance abuse felony punishment facility. So Ms. Saunders, have you ever had drug treatment before?
No, Your Honor.
And so what do you expect to happen when you get down there? In your mind, what do you think drug treatment is?
To cope in a different way, than what drugs give, I guess, a drug user. So
I think
easy to explain it.
Yeah, I think that's fair. I think that's very fair. A lot of it's going to be about education. And it's going to be education about drugs. It's going to be education about the cognitive impairment that drugs have. It's going to be about cognitive, retraining cognitive processes like decision making, deciding who your friends are, deciding how to get yourself out of circumstances, to avoid those things. And as you said, how to cope without methamphetamine or cocaine or whatever your drug of choice is, marijuana. And so it's not a magic wand. They don't give you medicine that keeps you from wanting methamphetamine or any other controlled substance. It's more about changing you on the inside rather than treating you from the outside. You understand that? So when you go down there, it's going to be about how much effort do you want to put into it? How much education do you want to receive? And a lot of that's going to depend on your outlook. It's going to depend on your attitude, and it's going to depend on your goals. When you get back, if you go down there and you do what you're supposed to do, you can come back with a lot of tools that will help you fight your addiction and hopefully keep you out of jail and prison and get you restored back to your kids and your family and your freedom, your liberty of living outside of a jail. You're a young lady, are you not?
Yes, Your Honor.
How old are you?
26.
26, you're a very young lady. So when you go down there, I just challenge you to put aside any preconceived notions that you have about who you are, about what you're worth, about what you stand for. I ask that you go down there and you wipe the slate clean, you be a blank page, let them educate you, learn that stuff, come back, use it so you can be successful, okay?
Yes, Your Honor.
All right. You're welcome. You're welcome. All right, Ms. Saunders, you're hereby remanded to the custody of the sheriff. If you'll go with Deputy Everett, he's going to take your fingerprint. And when you get out of probate, when you get out of safety, probation will be there to help you, okay?
Yes, Your Honor. Thank you.
You're welcome.
Judge, I believe that concludes my business here at the jail. I'll be headed that way shortly.
Yes, sir. See you in a moment.
Thank you, Judge.
No, he does. All right, this is cause number CR 22-345, CR 22-346, State versus Charles Brandon Young. The court accepted Mr. Young's plea agreement earlier today, placed him on community supervision. There was a question about whether or not Mr. Young would be able to be transferred to the state of Florida. An issue was brought to the court's attention by the Van Zandt County Community Supervision and Corrections Department regarding the interstate compact transfer law. Go ahead, Mr. Manning.
Judge, my understanding from Probation, Mr. Gann, is that he's going to grant my clients a travel pass to continue working in the 48 lower states. All the while he's going to transfer or request a full transfer to Florida, which requires my client to stay out of the state of Florida for 45 days, is my understanding. During that portion of time, the transfer will be pending once during the pendency of that transfer. My client will be reporting here at least once, possibly twice, while we wait to hear back from the state of Florida, and then provided that the interview and documents can be established in Florida, then that transfer will happen, and he'll be able to continue working.
Okay, Mr. Young, you understand?
I want to hear.
You want to hear from me? All right, so Mr. Young, in order to transfer a probationer out of the state of Texas to any other state, the state of Texas has to comply with the interstate compact transfer laws. And what that requires is that the state of Texas seek permission from the receiving state to have a probationer transfer to their state. In order to do that, probationers have to be able to provide a legal residency where they're going to reside, where they're going to reside with. So, and the purpose of that is so that the receiving state, they're going to look at your background, they're going to look at your criminal history, they're going to look at all these things and determine whether or not they want you to be transferred into the state. And one of those things is that you have to have a legal residency there. And during the period that they're investigating that, they do not allow you to come and live in the state. They don't want you in the state until they approve you to be in the state. And that's what Mr. Manning is talking about. The 45 days is how long the state of Florida will have to conduct the investigation and either approve you or deny you. Because they could deny you as well. Okay. And so if you are in the state of Florida within that 45 days that they're conducting that investigation, and that 45 days may not start till tomorrow or Monday, I'm not sure. It's whenever we actually send the transfer paperwork to the state and they receive it. If you're in the state of Florida within those 45 days and the state of Florida discovers that, then they could deny you because then you've come without permission. In layman's terms, does that make sense? And so the probation office here is going to allow you to continue working. They're going to give you travel permits to travel to all the 48 states in the United States so that you can stay gainfully employed while we're waiting on this transfer to be presented to the state of Florida. Hopefully, everything goes well and you're able to be admitted into the state of Florida, and then you can go have your legal residency there with your mother and your son, your family. And then probation in Florida will have a place to come and check on you, because that's what they're required to do under the law. Make sure that, you know, you're not drinking, doing drugs, possessing weapons, all those things. Sure.
My boss sent me to Florida for
If your boss makes you go to Florida,
well, typically in this industry, Florida sucks. Come down to money, running numbers and stuff like that, speaking my language, and but no one really goes to Florida like that, but on an occasion, you will get a good load from Florida. It's just, you know, the voice come out. That's the reason why I think we don't go.
sure. And can you not tell your boss what it is that you're waiting on, what prevents you from going? I
don't
mean,
have a problem with the whole entire situation and what's going on. I'd rather him know what's going on with you guys and everything, including with you, so that way he's up to date with the driver than random with the driver to put on probation and something like that.
Sure.
You don't know.
well, I'm sure that if we need to, the court or the probation department could give you a letter that says that you're not to enter into the state of Florida during a certain period pending a probation transfer application.
With all due respect, sir, all I know was telling them something before.
Yeah. Yeah, so if that's the case, if he will cooperate with you, then that solves the issue. If it's going to be termination or go, then I think you would have at least a defense as to why you shouldn't be terminated. And the court could, or probation department could give you a letter for your file that says after this period you can go, but before that period you can't go. Okay,
I understand.
all right, good. All right, so it seems like we got a game plan. Hopefully everything goes well and we get you situated and we get you transferred. Other than that, Mr. Gann's he is the expert on transferring from state to state. So if he tells you to do this or don't do that, I follow his advice, because if we don't, then the state could reject you and then we could have a whole other issue about where you're going to be. Okay. All right. Thank you. You're welcome. Thank you, Mr. Young. Mr. Waller, you ready, sir? Come on up. All right, this is cause number CR 23-42. And CR 22-395-396, State of Texas versus Caleb Wayne Waller. Mr. Waller, if you'll raise your right hand. Mr. Waller, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir. Thank you. I can't remember, did we start any of this plea process, Mr. Manning? I think we got halfway through this, did we not? We're gonna go.
The second time.
We're gonna go ahead, we're gonna go through it again, just to be safe, okay? All right, Mr. Waller, are you a United States citizen who reads, writes, and speaks English? Have you ever been diagnosed with a mental condition? You're represented by your attorney, Mr. Manning. Are you pleased with his representation? Yes. Do you feel like you've had enough time to talk with him about your case? Yes. And the paperwork that you've signed today, you understand everything and you don't have any questions, correct? Mr. Manning, do you believe Mr. Waller to be competent today?
Yes.
And have you advised him as to his right and also the advantages and disadvantages of a deferred adjudication plea?
I have, Judge, I've explained it on both the previous charges as well as its newly filed information charge.
All right, and to that end, Mr. Waller, you understand that you have the right to have your case presented to a grand jury, is that correct?
Yes, sir.
I may see one additional issue with this. So today's aggravated assault with a deadly weapon is filed by information, correct?
Correct.
Okay, Mr. Woodwhite, this says indictment, so I didn't catch that on the other two revisions, so we'll need one that says information.
Okay,
All right.
thanks, Judge.
All right, and so, Mr. Waller, you understand that you also have the right to waive the presentment of your case to the grand jury. And do you have paperwork, Mr. Manning? Do you have a waiver of indictment paperwork?
Judge, when I got here, the only thing I was given the initials of probation, which we reviewed in the case items.
So you don't have any of these papers?
No, Judge.
Okay. Tell you what, I don't know that we're gonna make it, because we're gonna go through all those. You got to sign all of them. For the aggravated assault.
Yeah. Having gone over the paperwork before. Judge, do you know if the city provided correction?
If the state has provided what? I believe that is the correct, actually, no, so we're just gonna have to mark through. Mr. Woodwhacker, are you gonna send over a corrected?
I'm working on emailing it right now, Judge. But if we just want to mark through the one on there, and I'll switch it from indictment to information, we'll get that sent over to Miss Patty here in just a minute.
Yeah,
All right, Mr. Waller, and you understand that you have the right to waive the grand jury and allow the state to prosecute you by an information, is that correct? And you understand that you and only you can waive that right, and if you waive that right of indictment, you must do so intentionally, knowingly, voluntarily, meaning you must do that because that's what you want to do, not because you're feeling pressured or think that's what you have to do. You understand that?
Yes.
And are you waiving your right to have your case presented to the grand jury today? And you're doing so of your own free will in court, is that right? All right, the court will find that Mr. Waller has been admonished as to the presentment of his case and right to the grand jury. The court finds that he has intentionally, knowingly, and voluntarily waived that right of indictment. Court finds that Mr. Waller is being prosecuted on the second-degree felony offense of aggravated assault with a deadly weapon, which carries a range of punishment of not less than 2 years or more than 20 years in prison, and carries a fine, if imposed, not more than $10,000. The plea agreement in this case appears to be that you would plead guilty to that crime in exchange for the state's recommendation that your punishment be assessed at 6 years community supervision, deferred community supervision, a $2,000 fine, $60 restitution, and the state would be dismissing an intoxication assault with vehicle causing serious bodily injury in CR 22-396.
And Judge, they're also going to need to be dismissing the additional 395 as well.
Is that true, Mr. Woodward? That's not on the judgment either, so you'll need to include that if y'all want that in the. If y'all want that a record in the clerk's record.
This is intended to resolve all the cases, Judge. I assume.
So we'll need to say CR 22-396 and CR 22-395. Mr. Waller, do you understand that if I approve this plea agreement today and you're placed on community supervision, if you violate any of the terms and conditions of your community supervision, and you've had an opportunity to review those today with your attorney and you sign those, if you violate any of those, the state could file a motion to adjudicate your guilt, which means they could file a motion to bring you back before the court. The court could do a number of things based on hearing that evidence. Some of those things could be the court could adjudicate your guilt, convict you, the court could revoke your community supervision, and the court could decide to assess punishment. And if it does so, it could assess that punishment anywhere from the minimum 2 all the way up to the maximum 20. Understanding that, you still wish to go forward? All right. Then, Mr. Waller, how do you plead to aggravated assault with a deadly weapon? Guilty, not guilty? Guilty? All right, court will accept the defendant's plea of guilt. Mr. Manning, any objection to state's evidence?
No objection to state's evidence, and Judge, just briefly, if I may bear the record just a little bit. We were provided this offer on Mr. Waller's case after our last setting. I conveyed that offer to Mr. Waller. He and I have both an email with discussion as well as the a phone discussion about the pros and cons of having these 2 other cases in order to go forward on this aggravated assault. I discussed with him the consequences of failure of probation. He's well aware of those prior to today. It's just a matter of getting paperwork all cleaned up, but he is aware and has been advised.
Okay. Anything further from the state?
Yes, Your Honor. The state's going to be we'll be dismissing 395. It's not a 1245 because this charge is basically what we're doing is we're refiling it as an ag assault. So we'll just dismiss this charge. There's not 3 victims. The victim in this charge is the victim from 395. So we will be doing a dismissal of that cause and not, it won't be reflected in the judgment. It will just be a dismissal because he is pleading in this charge.
Okay. And is there victim compliance and notification?
Let me take a look, Judge.
And Mr. Caden Waller is your family member, correct?
That's right.
Caden Waller, that your family member? That's your son? And he's the named victim in this case, correct? And what was the level of injuries to Caden? Spleen.
Judge, state is in compliance. We have provided a victim impact to both victims. The victim in both of these charges, and we have not received any anything back from them. I do believe that obviously one is his son and one is a relation of some variety to his. I'm not unaware if it's a family, a friend, something of that nature, but they are related to him in some form or fashion. We have not received anything back from them.
And as far as the evidence supporting the plea, what I have is a copy of the information. That's all that I have. So can you give me, Mr. Woodwife, the evidence to support the plea?
Yeah, if you give me a minute, Judge.
You don't have anything more, Mr. Manning. You don't have a copy of the state's wanting offense report or anything?
Judge, it would be the same as what was previously offered. And I'm looking through my stuff right now to see if I have the old paperwork.
I think I returned all that to you.
The state.
Judge, I guess we would offer State's Exhibit 1, which would be the offense report. If Mr. Manning has no objection, I can bring that over later. I can give a brief synopsis at this point to support the plea and then provide the actual written report into evidence. Likely tomorrow, given the time.
No objection to that, and as I would point out, it's the same, special evidence report reviewed, previously, last month when we attempted to play on assault, in assault.
Yeah, go ahead, Mr. Woodward.
Judge, on the date in question, DPS is dispatched to a 2-vehicle crash at Highway 19 and 859, a white Ford F-250 pickup with front end damage and a white Nissan Altima, which is the vehicle driven by the defendant. The driver of the F-250 states that the Altima disregarded a stop sign and basically they had a collision. DPS puts the defendant through standardized field sobriety. He has 6 of 6 on HGN, 3 of 8 on walk and turn, 1 of 4, but it stopped because the defendant claims a bad ankle. He provides a blood draw. I believe Mr. Waller consents to. Just as it was drawn. I don't see a warrant, so I'm assuming that is a, correct me if I'm wrong, Mr. Manning. Is this a consensual blood draw?
Yes, that is correct.
And then the lab comes back at 0.176 BAC. There are some other appears to be signs of intoxication, a few empty alcohol containers in the vehicle, nothing full, just empty containers. And in this case, Mr. Caleb Waller is transported to the hospital. And we do have a large amount. We're not going to submit them into evidence because they are a child's medical records, but he does have, I believe, a lacerated spleen.
All right, thank you, Mr. Woodward. Any objections, Mr. Manning?
No objections to that, and that is an accurate reflection of the reports.
All right, and so Mr. Woodward, I would ask that you provide State's Exhibit 1 with those offense reports into cause number CR 23-42. Court has admitted those. And I believe at the last time we talked about coordinating evidence of SBI based on the refiling. I don't believe that we need that now. So we talked about, it jogged my recollection that we were talking about having a sealed copy of the medical records to prove SBI. However, now with charge, I don't believe that to be necessary. So if you'll provide the offense reports, I think that would be sufficient.
That's good, Judge, because it's about, just looking at it's about 1,500 pages of records. We'd rather not have the clerk have to keep up with all that under seal. So I will absolutely provide the offense reports as State's Exhibit 1 in due course.
Well, I would have ordered you to put it on a flash drive and put it in an envelope. So,
however, the court would like us to proceed.
yeah, not necessary. All right, Mr. Waller, based on the evidence, the court finds that there is sufficient evidence to convict you of this offense. The court will follow your plea agreement today. The court defers a finding of guilt on aggravated assault with a deadly weapon, defers any finding on the deadly weapon. The court assesses punishment at 6 years community supervision, places you on, or assesses the fine for $2,000, $60 restitution, $290 court costs, $515 reimbursement fees. The court dismisses under section 1245 CR 22-396, intoxication assault with vehicle causing serious bodily injury. And the court notes for the record, the state is dismissing cause number CR 22-0039. Mr. Waller, you're handed to the custody of the probation department so they can carry out the terms and conditions of the sentence. If you'll come forward to be fingerprinted with Deputy Everett, then the probation officers will give you the information on the next step.
Sir, Mr. Rothman.
All right, and I believe that concludes our docket for the day, so the court will be adjourned. Thank you, Mr. White.
2 for 2.